here, a couple more straggling in, and I've got a couple minutes after. You guys ready? So good afternoon, everybody. Thank you. I'm Steve Irwin, President of National Reverse Mortgage Lenders Association, and I want to thank you all for joining us here today. Just a quick reminder that today's webinar is worth 1 CRMP credit, and Daryl and the team here at Normala will ensure that your credits are properly logged and you get full credit for this. An integral part of Normala's mission is to provide our members with best-in-class educational content, both in person and in this virtual environment. And to that end, Normala not only manages the Certified Reverse Mortgage Professional Designation Program, and also has a very active education committee under the leadership of Open Mortgage's Jim Corey. But we also conduct periodic outreach to our members so as to better understand what training topics are of value to you all. In our outreach to the Certified Reverse Mortgage Professionals recently, it became abundantly clear that there's a desire for us to deliver to you all training on servicing related topics. So today, we have gathered the nation's preeminent reverse mortgage servicing experts. As you know, there's been a series of COVID-19 related policy proclamations from HUD over the past year. HECM servicing timelines have necessarily been adjusted and refined. It's all become fairly confusing. And to help us sort through these policies, we have with us today Gail Belletti, Leslie Flynn, Michael Christine, and Rex Lamb. Gail Belletti has served as Senior Vice President, Borrower Care and HUD Investor Relations for C-Link since joining that firm in 2018. Prior to working for C-Link, Gail spent 12 years at Financial Freedom as Senior Vice President of Servicing Operations. Gail has over 25 years of mortgage operations and management experience, including 14 years in the reverse mortgage space. Gail's responsible for managing borrower care, including all inbound call centers and borrower-facing processes such as line of credit draws, payoffs, and payment plan changes. Gail co-chairs Normala's Servicing Committee, and she's also very active on the HUD Issues Committee. Gail attended the University of Texas in Austin, and she majored in business administration there. Thank you, Gail, for joining us.
Sure.
Leslie Flynn is with Reverse Mortgage Solution. Leslie joined RMS in 2011, where she was responsible for the REO division. In 2012, Leslie assumed responsibility as SVP for all aspects of servicing, HUD regulations, and compliance within servicing. Previously, Leslie was a consultant for the Solomon Edwards Group, where she was directly involved in banking resolutions and asset liquidation for a government entity. From 1989 to 2008, Leslie served in a variety of financial and operational director positions within Washington Mutual Bank and its predecessor, Bank United, which included servicing operations for the commercial real estate lending portfolio, servicing operations for commercial banking, branch acquisitions, and consolidation and corporate mergers and acquisitions. Michael Christine is with Champion Mortgage. Michael has over 15 years of experience in the reverse mortgage industry and is an active member of Normala's Servicing Committee. He's managed oversight of the customer service call center, customer relations, loss mitigation, community outreach, and loan administration while at Champion Mortgage. Prior to joining Champion, Michael was with Bank of America and then Wells Fargo, where he oversaw reverse mortgage servicing operations, including customer service and loss mitigation. We also have with us today Rex Lamb from C-Link. Rex joined C-Link in June of 2018, and he brings with him over 25 years of mortgage operations, compliance, and management experience. Rex is responsible for managing C-Link's risk department, which includes risk management, escalations, quality control, vendor management, and state licensing. Prior to joining C-Link, Rex was with Financial Freedom as director of late-stage defaults, including foreclosures, REOs, and bankruptcy. Prior to joining Financial Freedom, Rex held officer titles at Saline Finance and Litton Loan Servicing in Houston, Texas. He was responsible for servicing compliance, default operations, and analytics in a variety of positions. Rex is an active member of the National Reverse Mortgage Lenders Servicing Committee and our State and Local Issues Committee. Before I turn it over to Michael, I'd ask that you submit any questions you might have through the Q&A link, which is at the bottom of your Zoom screen there, or you can submit questions through the chat function, which is also at the bottom of your Zoom screen. We'll get to your questions after our panelists walk us through the COVID-19 moratoria guidance as issued by HUD. And on that note, Michael, I'll turn it over to you. And thank you all once again.
Great, thanks, Steve. Thanks everybody for joining today. Over the past year, we have watched a number of our HUD extensions change dates throughout the past year. But today we'll walk through where we currently have guidance based upon HUD's publications. So currently we have a foreclosure moratorium that's in place through June 30th of 2021. This is based upon the Mortgagee Letter 2105. This foreclosure moratorium prevents servicers from moving loans forward into foreclosure unless they are related to a vacant or abandoned property. There's also an eviction moratorium, again, with current expiration good through June 30th of 2021. This prevents any evictions, whether they're foreclosure related evictions or REO evictions. There are also borrower extensions available, again, good through June 30th of 2021. Borrowers can contact servicers via phone or letter and request these extensions. Excuse me. Also, there's exterior only appraisals. So appraisals are only done on the exterior to prevent anybody entering the home that may jeopardize the safety of the borrower. Excuse me, Steve, can somebody take over for me real quick?
Sure.
Rex, can you do that?
Yeah, I'll keep walking through this. So also, there were 2 or 3 waivers that HUD has announced over the past year. First being the $5,000 repayment plan cap, which allows a borrower that fails a repayment plan to obtain an additional or a new repayment plan if they qualify based on their financial information. Having a default balance greater than $5,000 no longer would prohibit a servicer from offering a second repayment plan. This and the following the following waiver were announced in FHA Info 2107. Verbal occupancy certification waiver was announced in that same FHA Info document that allows servicers to assign a loan to HUD with just a verbal occupancy certification, not requiring the borrower to send in a written certification in order for that assignment claim to be filed. Finally, for eligible non-borrowing spouses, so these are the non-borrowing spouses that are on case numbers issued after August of 2014. Those eligible non-borrowing spouses no longer have to obtain the right to remain or be on title within 90 days of the death of the borrower. That waiver was announced in October 1st of last year, and it is good through September 30th of 2021. It was announced in FHA Info 20-72. So I think we're ready for the next slide.
Okay, I'll take this one, Rex. Thank you.
Mm-hmm.
So with regard to state level guidance, servicers are all monitoring the state level guidance and regulations. Thus far, the HUD moratorium supersedes all the state guidance that has been issued. Just as an example, there's a Oregon specific notice that was required to be provided to Oregon borrowers, and NORMLA provided a version that was applicable for reverse mortgages for the servicers to use. So that has been sent out to Oregon borrowers and continues to be sent out to newly boarded Oregon borrowers. And then there's a hardship affidavit in New York that is required to be sent for loans in foreclosure, and our legal counsel is sending that hardship affidavit with their notifications to borrowers or to the estates. So we will continue to comply with state level issued guidance unless it's of course inapplicable to HECMs or reverse mortgage loans in general. And we will, when the moratorium actually ends, we will take another look at all of that state guidance to make sure that nothing extends past what the federal moratorium provides, to make sure we are all in compliance. Okay.
So let's talk about the extensions that HUD first announced in Mortgagee Letter 2006 and has now extended with the most recent Mortgagee Letter of 2105. So far, servicers have entered thousands of these extensions into Hermit. HUD announced in August of last year and the changes to Hermit that allow these extensions to be entered by the servicer. The original announcement in, I guess it was April of last year, announced 2 6-month extensions that the borrower or the lender, the mortgagee, can request. These 6-month extensions begin with the date of the request, and if it's a pre-due and payable extension, the borrower needs to be contacted and request the second extension. For mortgagee optional extensions, those can be placed through Hermit as long as the first extension is not expired. Within Mortgagee Letter 2105, HUD announced 2 additional extensions that are eligible for loans that had the initial request received at least by June 30th of 2020, so at least by June 30th of last year. The borrower or the mortgagee can opt in for 2 additional 3-month extensions. Again, borrower would need to request those if the loan is pre-due and payable, and after the loan is due and payable, either the borrower or the mortgagee can make the option to request those additional 3-month extensions. HUD does not require that any evidence be gathered other than if it's a borrower request that our servicing system be documented that the request was received. All of these extensions, according to Mortgagee Letter 2105, must terminate by June 30th of 2022. So June 30th of next year. Next slide, Daryl. Okay. We're also going to talk about the moratorium or the moratoria, which were put in place originally by Mortgagee Letter 2004 and have now been extended again in the same Mortgagee Letter we were just talking about, Mortgagee Letter 2105. So the moratorium currently, the foreclosure moratorium now that Michael was talking about earlier, it prohibits servicer from moving for first legal action or moving to sale to complete the foreclosure action through June 30th of this year. After June 30th of this year, HUD has given the servicers 180 days to meet the next eligible timeline. So for first legal actions, servicer would need to meet their first legal action within 180 days from the end of the moratorium, which again is scheduled right now for June 30th of 2021. Based on the documentation we've received or the questions we've requested of HUD, we're applying, and all the servicers are applying these extensions separately, are applying the extension we talked about earlier separately from this extended moratoria. We're not stacking the expiration dates. So if the request for a extension that we were talking about previously is on our system, it's running concurrently with the moratorium and the additional 180 days following that moratorium. Vacant, as I think Michael also mentioned, vacant and abandoned properties are excluded from this moratorium, and servicers are moving forward with foreclosure actions on properties where the property is vacant or abandoned. Okay, I think someone else is available on the next slide.
Okay, so I'll take this one. Thank you, Rex.
Mm-hmm.
So borrowers have been contacted in every way we could figure out how to contact them. The servicers have sent millions of statement stuffers every month. I know we've sent statement stuffers every month since last April or May, I believe. We're coming up on a year, encouraging borrowers who are financially impacted by COVID to reach out to the servicer. We've sent the Oregon notices, as I mentioned before. We've had dialer campaigns and outbound phone campaigns to reach borrowers, especially with regard to extension expirations and renewing those extensions. We've updated our website and put special messages on our IVR, and our website has a banner. I think several of our websites have banners on them instructing borrowers what to do if they're COVID impacted. So there's been a significant borrower outreach across all of the servicers. And I know, for the loan officers attending the call, it's especially important for you guys to know what to tell your borrowers if they contact you, because we know they will often call you first. And the best thing you can tell them is to reach out to their servicer. And the phone number is always on their mortgage statement. In the case of the communications we've sent out via the statement stuffers, there's a special campaign phone number that essentially goes to the same place so that we can track the number of calls that we're getting. Okay, Daryl.
So the potential challenges to we as servicers to ensure that we protect borrowers and our entitled non-borrowing spouses suffers from the same phenomena that the world is suffering from, which is that the supply chain for whatever product you're trying to deliver has been hopelessly disrupted in regard to our ability to foreclose or our ability to delay a foreclosure. What we are facing is that should a borrower or an heir choose to try and pay off the loan or sell the property and we need to do an appraisal, there's significant shortage of FHA appraisers. This also impacts us when we get ready to foreclose because we need a foreclosure very close to we need an appraisal very close to the foreclosure date. So to ensure that we bid the right amount. So the shortage of appraisers obviously is due to the phenomena that we have a refi boom going and interest rates are very low for new purchasers. It's also very expensive today to obtain an appraisal. Puerto Rico faces a dilemma at every turn, and they continue to face problems with closings due to COVID and their natural disasters. So Puerto Rico is no different than America, but it seems to have its own series of issues which make foreclosing or selling properties in Puerto Rico very difficult. The supply chain is particularly disrupted when it comes to obtaining legal services. The county recording offices are impacted by COVID. Many have never recovered since the onset last March. And so it is very slow in any kind of recording or title curative work that needs to be done to allow for a loan either to be sold or excuse me, even for a short sale or for foreclosure. Judicial state court backlogs are going to be inevitable. The whole world has been on hold. The moratorium applied not only to reverses, but to forward. Therefore, we believe that there will be an avalanche and we'll all be racing to the court. And I'm sure there's going to be backlogs. And it isn't just the court action, it's mediations, it's getting on the dockets. We believe that that is why HUD granted 180 days after the moratorium is lifted to allow us to take the first legal action, simply because they recognize that it's not possible to operate in the ordinary course of time. Another area is that attorneys and the attorney firms that we all use have been out of business. They've had to turn to other avenues to maintain any level of revenue flow. And they've oftentimes furloughed their best foreclosure attorneys. So they'll have to and are firing up the troops, getting ready for the inevitable. But getting the machine working again will take some time. Now, in addition to that, there are documents that have to be reviewed, signed, and notarized. And that is an internal as well as a external law firm sort of joint responsibility, and there will be a significant amount of documents to review and notarize, causing further delays. Attorneys prepping files, we were not allowed to charge borrowers fees during this moratorium if they've asked for a COVID extension. So we really had to put those files on hold. And when we turn those to attorneys, they have lots of work to do to take that first legal action or to start to commence or, recommence the foreclosure action that was stopped by the moratorium. Assignments of interest for the doc chain, for the legal chain, will obviously be impacted, as well as the appraisals, the legal, the whole shoot and match is going to be a race to the finish line. Now, what does that mean for borrowers? That means further delays. For the borrower or the heirs who wish to get on with it, they're going to be impacted. For those who are just waiting for the inevitable, they may in fact find that they don't see a lot of action as soon as that moratorium is lifted. But we as servicers believe that as soon as borrowers and heirs start seeing the foreclosure wheels start to turn again, they are going to seek some relief. And if they have not sought relief by June 30th, we are going to be limited in the amount of assistance that we can provide. So for any of you who have customers or who originated a mortgage and who now are in default, or for anyone who's seeking assistance from you, please have them call their servicer to see what it is that we can do to assist them in delaying the movement on their property or the movement on their parents' property. And Daryl, I think we can now take some questions if there are questions from the audience.
Don't have any at the moment.
So there was a question that came in, a little unrelated. Gail, did you want to answer that? And I would remind attendees that we've got the leading servicing expertise right here, right now. So if you have a question on the moratoria or other servicing related issues, questions, concerns, please type them into the Q&A at the bottom of your Zoom screen, or you can use the chat function. Gail, did you want to take this random question came in from one of our attendees?
Sure. So thank you, Steve. The question is, says, I closed a loan 3 years ago and now the service company is calling and offering refis to my client. Is this a normal practice? So it is a normal practice amongst lenders to solicit borrowers for refinances, yes. You won't find a subservicing company doing that necessarily, but the lender, yes.
So that is not something that the lender, the servicer isn't soliciting for refi. It is the lender of record that may be trying to solicit or not.
And that lender of record could be the master servicer as well.
Or it could be a competitor who has knowledge that the borrower has the reverse mortgage.
Right, because those records are a public record. They're recorded, so.
But a servicer isn't soliciting. So Gail, interesting, you mentioned master servicer, subservicer, and there has been a question of what's the difference? Would any of you like to explain the master servicer role versus subservicer role?
So I don't know that it's actually a question, Steve. That person who is anonymous responded that there's a difference between a master servicer and a subservicer, and that is correct. And the master servicer is often a lender, and those lenders would solicit the portfolios for refinances. A subservicer would not. Rex, do you want to add anything with regard to differences?
Yeah, I mean, the master servicer is the one that actually owns the servicing rights, and they contract out with a subservicer to perform the servicing functions. I guess that would be the way I would draw the distinction.
Right. Steve, I see that there's a question regarding someone who's on the phone, Nina Penny, who says that she has a client who recently passed away and his son would like to sell the home. He called the servicer and they sent him paperwork for a deed in lieu, but he would like to try and sell it. What steps should he take? And I think that we would all say that he should call a servicer back, indicate that he would like to try and sell it. It may be, Nina, a couple of things. The servicer may have had an appraisal done, an exterior appraisal, which we typically are required to do. And they may understand that the value of that property is significantly less or slightly less than the loan balance that needs to be paid. And therefore, when the borrower or the heir, in this case, would sell the property, there would be inadequate funds to retire the loan. So he should go back to his servicer and ask whether a default appraisal has been obtained and whether or not a short sale is available, or is there equity in the property based on the default appraisal that has been prepared?
Thank you, Leslie. I hope answered the question, answered it for me.
Oh, now she's come back and says he has plenty of equity in the home. I don't think he explained it well. Well, it's very true that oftentimes it's confusing to both parties, the servicer as well as the person who's initiated the call, exactly which option they'd like to undertake. But if he calls his servicer back and talks about the fact that he has equity and wants to sell it, I'm sure that they will be able to address his concerns.
And since the next question also deals with timelines, I would just point to Nina that if the person is trying to sell the property contacts their servicer, they will probably qualify for 2 90-day extensions to the first legal time frame. So they should definitely be in contact with the servicer, find out what documents they need to provide in order to qualify for those extensions, and that way they have more time to sell the property. The question from Neil is about what timeframes follow due and payable. So this I'm going to have to answer in a normal period of time versus today, because today, right now, of course, we're in a moratorium. So all, due and payable actions are on hold until the moratorium ends, the foreclosure moratorium. In a non-COVID world, following the death of the borrower or following an event of due and payable, which could be, failure to pay their tax insurance, or not providing a occupancy certification, or providing notification they've moved out of the property, then the servicer has 6 months in which to initiate foreclosure. As I was just mentioning, the borrower, if they're attempting to sell the property, can qualify for 2 90-day extensions. But again, they need to work with their servicer, provide required documentation within the timeframes that the servicer needs those, because HUD does have hard timeframes on when the extension request can be accessed.
So, thank you, Rex. And again, in non-COVID times, you say initiate foreclosure. So that has to be done within 6 months. What do you mean initiate?
So for each state, HUD has defined what it takes, what in their eyes is called the first legal action. So in order to complete that first legal action, though, the servicer is going to need to refer that file to an attorney, and typically that referral occurs 90 days prior to the due date, or 90 days following the borrower's death if they're deceased, and kind of right in the middle of that 6-month time frame. If the borrower or if the heirs have qualified for extensions, then the referral will be held until those extensions expire. But if no extensions have been approved yet, then the servicer will go ahead and refer the file to the foreclosure counsel so that they have enough time to do their title work and be ready to file their first legal action before the deadline expires.
That first legal action has to be within 6 months. So there will be communications to borrowers or estates and heirs that would be before the 6 month time. It's the first letters aren't going out at 6 months.
No, the due and payable letter, HUD requires that to be sent within 30 days of an early event. Typically, it's when either the servicer finds out about the death, or 30 days following HUD's approval of the due and payable. So within 30 days of the loan being called due and payable, the borrower or their heirs should receive a due and payable notification that lays out what the event is that caused the loan to be due and payable, and what are the loss mitigation options that are available for that borrower or their heirs.
Right. So Neil, does that answer the question? I don't know so much. I don't believe borrowers are being told shorter timeframes, but they're getting communications in the mail earlier, which may lead them to believe they don't have the 6 months or the extension 3-month extension periods.
Right, but they do. And so if they stand firm on that, I'm sure that they will get the right conversation going with their servicer. Tim has asked a question, which is oftentimes encountered, which is, what if there's no equity left? Can the local realtor, with the assistance of the son, sell the home, even though it would be a short sale situation? So Michael, can you explain what the definition is of a short sale and what we can accept when the heirs wish to sell the property?
Sure, I can. I apologize earlier. Allergies got the best of me, so good to be back. So correct, you are able to sell the property at a lower amount. That's 95% for the older book of business based upon the current appraised value or the current unpaid principal balance. There is a lot of good information around short sales at reversemortgage.org, as well as on some of the servicers' website. So just around this general conversation, just want to remind everybody, but there is information at the NRMLA sponsored reversemortgage.org website that would also help explain the due and payable process.
Michael, how
Yes.
do they get the appraised value?
Excuse me, Leslie?
How do they obtain the appraised value of a property?
Sure. They would work with their servicer to arrange an appraiser to come out to the property to do, in our current environment, the exterior appraisal. They should be working directly with the servicer. I know in our servicing organization, we work with realtors to provide information on the process and help them through that.
Yeah, and just going back to Neil's question, Neil, if you look at the NRMLA website, there's a lot of resource guides on there that I think will answer your question with regard to the due and payable timeframe and what borrowers can avail themselves of and the timeframes.
I would also say to Neil and others on the call that the CFPB has recently published its reverse mortgage borrowers' rights and responsibilities guide, which is very, very helpful. And Neil and all loan officers here and servicers here, I strongly suggest that you share this guide with applicants and borrowers. If you go to NRMLA's member website, normalaonline.org, and you look at the consumer guides section, it's right there in the banner menu, and click on consumer guides. There are a lot of handy guides there, and this new publication from the CFPB is also there. And I think you would all agree that, yes?
I'm thinking maybe it would be helpful if Daryl shared his screen and showed where those guides are on the NRMLA website.
Well, while Daryl's looking for that, I can answer Brenda's question and I guess Terry's question, or we can address hers. So Brenda's question, from March 18th of 2020 until scheduled right now, June 30th of 2021, that entire period for reasonable diligence, which I think is what you're asking about, that entire period will be an uncontrollable delay, including the 180 days that follows the expiration of the moratorium. All of that should be, you would say, carved out, removed, or added to the required time frame in order to meet reasonable diligence. So, you know, if the loan was on time prior to March 18th when the moratorium went into place, then all the rest of the time should be uncontrollable delay, and the servicer should be able to move for sale during the 180 days after the moratorium ends and still meet the timeline. Again, this assumes that the loan was on time prior to March 18th. And then Terry was asking about verbal occupancy status. So Terry, in the FHA info I was referencing, which we can pull back up in a minute, but that there's a waiver in that FHA info that waives the requirement to have a written occupancy status, a written occupancy certification in order to assign the loan to HUD. So if the servicer is in process of attempting to assign the loan to HUD and they don't have a current written occupancy certification, then they would reach out to the borrower to obtain a verbal occupancy statement at that time from the borrower.
Correct. And I'll just add that occupancy, that verbal occupancy is only acceptable to HUD in the case of an assignment. We can't use the verbal occupancy for other purposes. So Daryl has pulled up the location of the consumer guides on Normala's website there for you guys to see. So you can see on the right-hand menu, it says consumer guides, and there's lots of guides there. Daryl, you might want to scroll down to see.
Right, there's
There's
this,
a resource for homeowners who need help,
yeah.
what you need to know about your HECM after closing.
And I believe that's the document that we as servicers put together. And hopefully it will deal with the question that Neil had asked, which is some simple and clear guidance to share with their borrowers.
Right. And also, what do I do when my loan is due? That one is key for you, Neil. And where is the CFPB guide? I'm sorry, did I miss that?
That's the first one up here.
Okay, I did miss it. Yeah, there you go. You have a reverse mortgage, know your rights and responsibilities. So, you know, if I was a loan officer, I would be printing that off and handing it out to my borrowers.
Right. As well as the other two documents we wrote. Don't forget those.
That's right. There's lots of collateral there for you guys that we prepared so that you can help your borrowers stay informed, because we get it. You know, there's lots of different servicing rules, and even us as servicers have to go and remind ourselves of certain things from time to time. So I can imagine in a loan officer's life, when you're dealing more with originations, it's even more difficult to keep up with everything going on in the servicing world. I hope that answered that for you, Terry and Brenda, Neil.
And what happens if you don't meet those timelines?
You mean as a servicer, what happens to us?
Yes.
HUD encourages us to obey the rules, and to ensure that we obey the rules, what they will do is they will penalize the investor and tell them that you, the servicer that you hired to service this loan, failed to obey the rules, and therefore I am no longer going to pay you any interest on that loan from the date that that borrower missed a milestone, missed a rule. And when investors start losing money, they tend to be very cross with we as servicers. So we try to meet each of those HUD milestones to not only comply with what HUD requires, but to avoid the ire of our investors that we serve along with your customers.
So it's pretty steep financial penalty.
Yes, it can be over the course of a loan. If we miss the first milestone, perhaps notifying HUD of a due and payable event, or failing to send the demand letter, it can be $20,000 worth of penalties, $45,000 worth of penalties. It just depends on the size of the loan and the length of time that you have to wait for the claim to be filed, because the penalty starts the day you miss the event, and the amount of interest that isn't paid goes all the way through when the claim is actually filed with HUD after the collateral is liquidated. So that's why it's such a steep punishment. And we all try to work with borrowers, giving them as much time, because extensions are just that, they extend those milestones. But oftentimes borrowers or heirs are unaware, as you can tell from the questions, or they're late in getting started out of either fear or because they put off the responsibility or the need to get after it. And we understand that. But it is very, very concerning that heirs and borrowers who have COVID extensions available to them have not availed themselves of it. And so we all believe that any help you can provide to alert your customers that if they are impacted adversely by COVID in any way, that they should call their servicer and seek assistance.
couple of quick questions for you all. At time of closing, loan officers will identify an alternate contact. And so relative to that alternate contact, a couple of quick questions. A, would it be helpful to you all if an email address was provided with that alternate contact?
Yes.
And phone number and address.
And can that alternate contact transact on behalf of the borrower or get loan level information and data regarding that borrower's case?
Not until they are authorized by the borrower or an authorized party on the account. They are simply a contact for us to reach out to if we cannot locate the borrower or reach the borrower, but we're not at liberty to discuss the loan details with a third party unless they've been specifically authorized by the borrower or another authorized party on the account. So the borrower can simply do that by writing a letter. I know we have a form and available on our website too, that where the borrower can complete it and sign it and authorize whomever they wish to have access to their loan details. But with regard to transacting any activities on the account, that's limited to someone with a power of attorney or a conservatorship or guardianship. And that would be items such as requesting a line of credit draw. An authorized third party can't do that. You'd have to be a power of attorney, an attorney in fact, or a conservator or guardian.
And Gail, I'll just add on the power of attorney and those authorized levels, those are specific to the borrower. So it doesn't cover both borrowers on a loan if you have more than one. So that's something that's key in educating some of the authorized third parties that reach out.
But for the garden variety, sort of additional information that we could use as servicers from loan officers, one, to encourage the borrower at the time of origination to identify an alternate contact. This is just somebody who can help us find the borrower in the event of a natural disaster or the fact that their mail is returned. And then if the borrower is desirous, having an authorized party is also good because health issues may cause them to be incapacitated in some way, not serious, but just not up to, making decisions for themselves. And an authorized party can at least assist them. They cannot transact, but we can discuss the situation and conditions of the loan. So both start with an A. The lowest level is an alternate contact. The next most powerful is an authorized contact. And then as Gail and Rex and Michael indicated, then you have powers of attorney, guardians, and conservators.
Thank you, Leslie. What else, Steve?
Not seeing any other questions right at this moment. Do any of our attendees have any other questions of our servicing experts here? Are there? Here's a question in the chat.
Yeah.
And so here, I don't know who wants to take it.
On the question on modified tenure?
Modified tenure.
Yeah.
So let's read the question first, right?
So if someone has a modified tenure payment plan and the HECM, this is a HECM loan and it's been assigned to HUD, The years of 10-year payments have caused a negative principal limit. I don't know, can the borrower still access funds remaining in their line of credit? If there are funds remaining in a line of credit, it couldn't be a negative principal limit. Am I not thinking of something here?
No, that's my understanding too, Steve, is that if the 10-year payment would continue, because it's a 10-year payment until the life of the borrower, even if it moves into a net principal limit negative situation, the payments would continue. But again, once the loan, it's a modified 10-year, so there was a line of credit set up, but once you reach a negative principal limit, you wouldn't be able to draw any additional funds from the line of credit.
The line of credit is limited by the principal limit.
Right.
Okay. And the next question says, if the loan was signed by the borrower but now has become incapacitated, the borrower, not the loan, the attorney in fact must provide a doctor's or doctor's, I don't know what that says, or doctor's letter stating the borrower had capacity and now has lost capacity, just like would have been required if the borrower had used an agent to sign the docs. So yeah, the issue there is if the borrower has recently become incapacitated and the power of attorney document is recent dated, we are going to want, as a servicer, confidence that the borrower signed that power of attorney when they were competent. So that's the issue there. Leslie and Michael, you
Yes,
agree?
No, I agree.
agree.
Laurie, does that answer the question?
And then Steve, someone had, yes, she says, thank you.
Yes, thank you.
And Steve, is this session recorded so that some of the attendees can either share it or listen to it again?
Yes,
Yes.
we will post it.
So there's one last question on Elisa from Jennifer. It says, if Lisa funds run out and borrower is unable to pay their taxes and insurance, will foreclosure start, or do you anticipate tacking funds onto the loan balance? Rex?
Yeah. Okay, so once the LISA, and this would apply to either fully funded or partially funded LISAs. So once the LISA balance either is zero or approaches zero, and the annual analysis shows that it's going to run out for the year, then set aside will be closed out. Now, that closing out of the LISA balance will inform the borrower that they now are responsible for their property charges. There's then the question of, is there a line of credit left on the loan? If there's a line of credit, the borrower could borrow those funds themselves to pay the taxes and insurance. If the line of credit is also expended, then they will need to pay for the taxes and insurance from other sources of funds. Loan would not go into a default situation until the servicer is advancing funds in excess of the line of credit, creating a net principal limit situation. Then the borrower would be notified, that the servicer is advancing funds on their behalf, and reminding them that they will be required to call the loan due and payable. They would have a short time period in which to resolve this situation. If they don't resolve it in 30 days, then the servicer would go to HUD to ask that they call the loan due and payable, and would start the due and payable process.
And in which case the borrower could qualify for a repayment plan at that time, correct?
Correct.
if they can't pay it all back at once. They would be evaluated for a repayment plan.
Right.
And
Also-
Rex, it looks like there's a follow-up question to see if there was notification when the Lisa runs out. I think you said there would be.
Yes, there would be a letter that's sent out. As I said, it either could occur if the LISA funds are expended or with the annual analysis, if it's determined that the funds, the funds won't last for the full year. Either of those events would cause the set aside to be terminated, and a letter would be sent out to the borrower to inform them that the set aside no longer exists and that they are now required to pay property charges themselves.
So the last question is, why is the turn time on payoff requests so long? Not meant to offend, just curious how to explain to clients. So Gail, you want to talk about the turn time on a payoff request for an active loan and then the turn time for a defaulted loan?
Sure, I'd be happy to. Just so you know, Leslie and Steve, also my comments and Q&A has frozen, so I can't see if there's anything else coming in. But you guys are watching it, so that's great. So on payoff quotes, there's a couple of things. I often hear the quote time is longer than anticipated. And when I look into those situations, more times than not, it's someone who's not authorized requesting the quote. So that's an important point, that not just anyone can request a quote. The person has to be authorized to request the quote. And so that's number one. Number two is on an active quote, the turnaround time is just a few days typically. Depending, when we went through the refi boom, we had some times when the time frame would get extended up to 4 or 5 days. But 2-3 days is much more common across all of our shops, I believe. Now, for a loan that's in default or has been in default or a loan in foreclosure, the time frame is longer because we've got to go out. Servicers have to go out on a variety of websites that belong to our vendors to obtain fees that have been charged to or billed, incurred, but not billed to the loan. So if we have inspections hanging out there or appraisals or legal fees that have been incurred but not yet booked to the loan, we've got to gather those fees to add them to the quote. So it takes a little bit longer if the loan is or has recently been in default or is in foreclosure. Any follow-ups on that?
Doesn't look like anything. Any other questions are open?
Okay, I guess if I could just take one moment, for loans that are subserviced by C-Link, we are rolling out our payoff quote functionality very soon. So our clients will be made aware of that very soon on our website, where borrowers who are in an active loan status can pull their payoff quotes instantaneously online.
Provided they have the login credentials. That's just not.
Right. Yes, they have to establish an account online.
Jennifer says that's awesome, Gail. But Terry wants to know, yes, Leslie,
You're on mute.
you're muted. You're mute, Leslie.
I have to run to another meeting. It's been fun talking to the loan officers. I'll catch up with you next time.
Thank you, Leslie.
Thanks, Leslie.
And we just got one more question here. Two questions, one for C-Link. Or no, this is for all of you. Can line of credit requests be made electronically, or is it mail or fax only? Or telephone?
So Steve, I think I can jump in there quick. So typically it is in writing. It's required to be in writing. So we accept mail and fax. Occasionally we do get an email copy if there's an emergency. There may be other options within other servicer groups, but typically it's a written form.
I'd like to add to that, Michael. We prefer fax and mail, and then of course our line of credit functionality is available on our borrower website as well. We stay away from emailed line of credit requests whenever possible due to security concerns.
And who's authorized to request a payoff, guys?
Sure. So
Company or a loan on?
So authorization for a payoff is the same as any transacting any other business on the account. They have to be an authorized individual, with the exception for C-Link of title companies and escrow agents who request those payoffs, usually on their letterhead, but they usually are accompanied with a borrower authorization, a signed borrower authorization form. But a loan officer cannot just request a payoff quote without a signed borrower authorization.
Or be an executor on the account, be the other option. Again, authorization. It's based upon the authorization, Steve.
Yeah.
Right.
Thank you, guys. Thank you so much. Once again, this has been very, very informative. We will make the recording available. We will get the deck out to people. And I would encourage all of our attendees on today's webinars, if there are other topics that you would like to see Normala present, other educational opportunities, servicing related or not, please contact Daryl or myself and let us know, and we'll see what we can do about putting it together. Gail and Rex and Michael and Daryl, you can't hear it because of the format here, but there's a thunderous round of applause happening for you right now. And I just thank you all once again. So take care, good luck, be safe, stay well. And thank you all. One question flying in, great presentation, says Sue. I told you it was thunderous. Take care. Thank you all.
Thank you.
Thanks,
Thanks.
everyone. Have a good day.